Hey everyone, it's Rohan here. So today I'm going to discuss this quite landmark legal case, the ruling of which just came out yesterday about the standing of the earned asset holder in the bankruptcy case of Celsius. And if we have not met before, in this channel, you will find me every day with my analysis on crypto market and macroeconomic global issues. So do subscribe and let me help you keep yourself updated. So if you are one of the roughly 600,000 people who entrusted $4.2 billion to an interest-bearing account with Celsius network, the bad news is that bankruptcy judge just said it doesn't belong to you. It belongs to Celsius. Celsius earned assets belong to bankrupt crypto lender, judge rules. The move confirms that crypto platform customers do not own their assets if they are using certain services or products. Now, to give you the background in this case, in September 2022, Celsius Network requested the court to return assets to what they call custody clients, but not to the earn and borrow clients. And what exactly is a custody client? It's similar in principle to a savings bank account with a traditional bank, often repayable upon demand by the custodian. In this case, a Celsius network has the fiduciary responsibility. So custody client account differs from an earn and borrow clients, as coins within the custodian account can be transferred, swapped, or used as loan collateral, but there are no reward earned on holding them. Celsius has an estimated 74,000 custodian accounts. Now, in contrast, coins held in the earn and borrow account will gain rewards but cannot be exchanged or loaned out as collateral. As of June 2022, Celsius reported having 2 million users around the globe and had raised an estimated $750 million from investors by late 2021. Now, Celsius' business model mirrored a traditional bank relying on fractional reserving system to receive deposits from crypto investors seeking yield and then giving out loans to turn a profit. Just as customers at traditional bank earn interest on their savings in dollars or pounds, crypto users that deposit their Bitcoin or Ether at crypto lending institutes like Celsius also earn money, usually in cryptocurrency. And similar to a bank, Celsius gathers crypto deposits from retail customers and invests them in the equivalent of wholesale crypto market, including decentralized finance or DeFi sites that use blockchain technology to offer services from loans to insurance outside the traditional financial sector. But unlike banks, Celsius promises retail customers huge returns, sometimes as much as 20% annually. The lure of big profits has led individual investors to pour assets into Celsius and a similar platform like this. Now, what could have caused Celsius's decline into insolvency? It looks like that their strategy required a continuous ongoing bull market in order to keep liquidity moving. So that means that more new users depositing on their platform to cover rewards and withdrawals for the current users. And it definitely looks like a Ponzi type structure that may have been set up by the leadership here. Some sources indicate that Alex Mashinsky, the CEO of Celsius, took control of the trading strategy a few months before the failure and frequently disregarded the advice of experienced investment managers there. Furthermore, it advertised itself as having a higher APY than other DeFi platforms and promised returns of 20% or more for the CEL tokens. So now it's obvious that those kind of high return was never supposed to be sustainable in a cyclical downturn, and further, the borrowers who borrowed from Celsius, their credit profile was pretty high. Now, traditional banks, they have a long time to refine their credit risk procedure and have huge amount of data to do data analytics and credit profiling of customers, but Celsius for sure did not have those expertise or huge amount of data backing any analysis. So when the liquidity crunch occurred, similar to the Northern Rock bank run in 2008, Celsius was quick to recognize the implication of a fractional reserving. In such a situation where a large number of depositors make demand simultaneously, no bank or lending institute can fulfill all withdrawals requests. So as soon as the warning sounded, Celsius froze both trading and withdrawal. And later they filed for Chapter 11 bankruptcy. And in September 22, they requested, that is Celsius Network requested the court to return assets to their custody clients, but not to earn and borrow customers. And the reason that they put forward was that the custody clients retained beneficial ownership of their coins, so they don't form part of Celsius's bankruptcy estate. All right, and now I'm looking at this 45-page judge ruling that just came out yesterday. So let's go through some of the important part. All right, so who owns cryptocurrency assets deposited in earn accounts by Celsius account holders before the July 15, 2022 petition date? This is a getting issue at the center of many disputes in this case. As explained below, the court concludes, based on Celsius's unambiguous terms of use and subject to any reserved defenses, that when the cryptocurrency assets, including stablecoins discussed in detail below, were deposited in earn accounts, the cryptocurrency assets became Celsius's property, and the cryptocurrency assets remaining in the earn accounts on the petition date became property of the debtor's bankruptcy estate. And at the petition date, Celsius had approximately 600,000 accounts in its earn program, and such assets, including any proceeds thereof, the earn assets. These earn accounts held cryptocurrency assets with a market value of approximately 4.2 billion as of July 22. Alright, and this is kind of the most important part of the court ruling, that if the cryptocurrency assets in earn accounts are owned by the debtors, the account holders are unsecured creditors, and their recovery depends on the distributions to unsecured creditors under a confirmed Chapter 11 plan or under Bankruptcy Court's priority rules in the event of liquidation. A fundamental principle of the Bankruptcy Code is equality of distribution. There simply will not be enough value available to repay all account holders in full if only some account holders prevail with their arguments that they own the cryptocurrency assets in their accounts. They hope to recover 100% of their claims, while most of the account holders are left as unsecured creditors and may recover only a small percentage of their claim. And that's exactly why whenever you are entering into a contract with the crypto exchange or dealing with any crypto trading or assets, it's very, very, very important that you read the terms of the contract. That is, the devil is in the detail. Look at this part of the court rulings. It makes it so obvious the importance of the terms and conditions. So the ruling says the court finds that account holders understood that they were assenting to a contract governed by the terms of use, even if the account holders chose to read some or none of the provisions. Mostly what we do, that we just don't read and just click on the accept. So it further says the court empathizes with the frustrations account holders may feel if they did not read or understand the specific terms of the terms of use. Frankly, though, the rules provide needed certainty and predictability required for modern commerce in the digital era. The law in the Second Circuit is clear that click-wrap contracts such as terms of use are valid and binding. The debtors have sufficiently shown the mutual assent element of contract formation. For the foregoing reasons, the debtors have convincingly argued that the three elements required to form a valid enforceable contract were satisfied by the account holder's acceptance of the terms of use via the click-wrap agreement. So again, because this court ruling will be such a landmark one across the world pretty much, so I'm going to go through this a little bit more detail to see the exact logic and thought process of the judge to come to this decision that the earn assets holder will become unsecured creditors and stand at the very last position in the queue to get their demands back, to get whatever is left after others are satisfied. And we will see in this ruling itself that the judge mentioned how reading the terms are so important, and even when we are just clicking on the accept button, whether it's on your mobile or laptop or computer, in the website or the mobile app, it carries so much legal weight. Because in the case of bankruptcy, like what we are facing in Celsius, when a user clicks on the accept button, whether on various version of the terms of use, they all come into the actual legal fights in the court, and based on that, the judgment will be affected accordingly. So let's see those parts actually. Yeah, so they mention how the various when the terms of use are updated by Celsius, and the clients that earn asset clients just accepted that, those are considered. So read this: each historical iteration of the terms of use provided that the debtor could amend the terms of use by posting them to their website, that the amended terms would replace the prior terms, and that continued use of debtor service following such posting would be deemed consent to the updated terms. This process requires an account holders to view a pop-up stressing the importance of reading the updated terms of use, and required 2 clicks, one checkbox and one accept. The pop-ups contained hyperlinks to read the updated terms of use, and account holders were informed of the impact of declining the updated terms of use. The pop-ups appear clean and compact and contained pertinent information in close proximity with a clearly bounded or full screen window. Together, these characteristics meet the standard for clear and conspicuous. So the court here pretty much is saying that the efforts from Celsius was clear and conspicuous to let the earned asset holders know that the legal position of their assets in the case of a bankruptcy. If an account holder did not affirmatively accept the updated terms version 6 within 2 weeks, the account holder's account was suspended until such time as the account holder affirmatively accepted the latest version of the terms of use. The court concludes that updates to the terms of use constituted valid modifications of the contract that an account holder entered when they created an account with Celsius. The terms of use unambiguously transfer ownership of earned assets to the debtors. Now, debtors here obviously means Celsius, and note these parts. So here it's very important. So there was various version of the terms of use from Celsius, and the initial version did not clearly mention the transfer of ownership, but the later updated version of the terms of use clearly mentioned that, and the users, that is the earned assets holders, that is the creditors, just clicked on accept without reading the entire terms. But in those updates, it was made clear that there will be a transfer of ownership of the earned assets. So reading this, in consideration of the rewards earned on your account. So yeah, so first let's read this. Terms version 1 does not contain any clause regarding Celsius taking rights of ownership upon deposit of earned assets. Terms version 2 to 4 contains the following text that discuss ownership but not transfer of title. So this is the terms version 2 to 4. In consideration of the rewards earned on your account and the use of our services, you grant Celsius the right, subject to applicable law, without further notice to you, to hold the digital assets available in your account in Celsius name or in another name, and to pledge, repledge, hypothecate, rehypothecate, sell, lend, or otherwise transfer or use any amount of such digital assets separately or altogether with other property, with all attendant rights of ownership. You acknowledge that with respect to assets used by Celsius pursuant to this paragraph, you may not be able to exercise certain rights of ownership. Okay, so that was version 2 to 4. Now coming to the most important, version 5, because that's where the changes came. So terms version 5 introduced the transfer of title clause that has been the subject of scrutiny in this matter. Every version of terms of use beginning with version 5 includes a clause that account holders grant Celsius all rights and title to such digital assets, including ownership rights. That is the most important transfer of title clause. And so it says account holders who agreed to terms of use version 5 or later, whether by signing up for the first time or by continuing to use the platform with an existing account, entered a contract which contained unambiguous and clear language regarding transfer of title and ownership of assets in earned accounts. At the hearing of this matter, Blonstein testified that 90% of account holders representing 99% of earned assets had assented to terms version 6 or later. That is, 90% of account holders had assented to this transfer of title clause that was very clearly mentioned in the terms of use. Going further, even if the court found that account holders loaned the digital assets to Celsius, account holders would still be unsecured creditors. It is black letter law that a loan of money or property to another creates a debtor-creditor relationship. Under New York law, a bank and its depositor stand in a debtor-creditor relationship that is contractual in nature. The bank owns a deposit, the depositor has a claim to payment against a bank, and the bank has a corresponding obligation to pay its depositor. Accordingly, a bank's temporary freeze of an account without more is neither a taking of possession of the depositor's property nor an exercising of control over it, but merely a refusal to perform its promise. And absent a perfected security interest in tangible or intangible property, in the event of a debtor's bankruptcy, the creditor holds only an unsecured claims. So this reference is very important. Absent of a perfected security, then the creditor will only be unsecured creditor. So now the question becomes whether there was any perfection of security between the depositor and Celsius. That is, whether the earned assets holder and Celsius. Let's see what the ruling says here. So indeed, by definition, an unsecured creditor has no particularized property interest in the debtor's estate. As a threshold matter, a claim cannot be a secured claim for the purpose of Section 506 unless it is secured by a lien on some specific item of property in which the estate has an interest, or alternatively is a claim that is subject to right of set-off. But more importantly, this is important, by current definition, cryptocurrency is not money because it is not a medium of exchange created, authorized or adopted by a domestic or foreign government or by an intergovernmental organization or by agreement between two or more countries. Moreover, since cryptocurrency, NFTs and other digital assets are intangible and therefore not capable of possession, a security interest currently can be perfected only by filing of a financing statement in the digital asset as a general intangible. Thus, even if the parties' contract purports to provide the creditor with a security interest in property, unless the security interest is perfected, under applicable non-bankruptcy law, a trustee can assert strong arm power under Section 544 of Bankruptcy Court to avoid the lien. And here, the language in the terms of use transferring all ownership interest to Celsius in the cryptocurrency asset deposited in the earned accounts makes it very clear that no ownership interest or lien in favor of the account holders was intended, and certainly no lien in favor of the account holders was perfected. Yeah, so there it goes. Now let's see what some others are saying. So does that mean that the creditors will not get anything as an unsecured creditors? In the long term, it does not mean that Celsius customers will get nothing, but they will be behind secured creditors and people who had non-interest bearing accounts at Celsius. Not that there were many of the later. And other avenues that these earned account holders may have in front of the legal system. So a dozen US states had fought Celsius current management's attempt to claim ownership of the fund, saying that customers may not have understood the terms and that the company was under investigation in several states for regulatory violations that might prevent it from enforcing the terms of service, or that the terms themselves might have been illegal. And that includes the possibility that Celsius violated state securities laws. A majority of the states and the Securities and Exchange Commission have argued that crypto earned accounts like those offered by Celsius are actually unregistered securities offerings and thus illegal. Indeed, another bankrupt crypto lender, BlockFi, paid $100 million in fines to the SEC and 32 state securities regulators in February 2022 to settle similar charges. Beyond that, Judge Glenn, who actually was presiding over this case here, so Judge Glenn noted that Celsius customers can continue to challenge the company estate's ownership of their funds on other grounds, including a litany of allegations, including but not limited to fraudulent inducement into the contract, fraudulent conveyance, breach of contract, and that the contract was unconscionable. Judge Glenn wrote, "These allegations may or may not have merit, and the creditor's rights with respect to such claims are explicitly reserved for the claims resolution process. So overall now it very much means that users who held non-interest bearing accounts and secured creditors, they will be considered first before those on the earn program. So whatever is left after paying the secured creditors, then earn programs will be paid, and nobody knows how much will be left over, if at all. So it's a pretty bad situation for the earn asset holders, and I just want to refer to this CNBC article that was published sometime in August when this court fighting was going on and was pretty hot during that time. Homeless, suicidal, down to last $1,000, Celsius investors beg bankruptcy judge for help. So one guy wrote, Christian Ostimer, a 37-year-old living in Connecticut, wrote in a letter to the judge included in court exhibits that he trusted Celsius with his retirement savings and has lost more than $30,000, which has brought him into unsurmountable tax complications. So he wrote, "It is in your hands, Honorable Judge, to make this a different case where not the lawyers, attorneys, the big corporations and managers get paid out first, but the little man, the mom and pop, the college grad, the granny and grandpa, all those many small unsecured creditors, so that they are not like usual at the end of the chain where they lose everything." But that's exactly the situation now. That is, all of them are in the unsecured creditors position and they will be at the very last end of the chain, and nobody knows how much they will get paid. That pretty much wraps up this video. If you liked it, do smash the like button, and also don't forget to subscribe. See you in the next one.